What if I told you that some marriages were never marriages in the eyes of the law? Not broken, not ended, but never valid from day one. Imagine standing at the altar saying, "I do," only to discover years later that legally you never did. In Nigeria, that's the reality of an annulment. Unlike divorce, which ends a valid marriage, annulment wipes it out completely, as though it never happened. But what makes a marriage invalid? Is it hidden facts? A prior marriage? Fraud? Lack of consent? Or something as serious as being married to someone else without knowing? In this video, we uncover the powerful legal truth behind annulment under Nigerian law. From bigamy, mental incapacity, undisclosed diseases, and non-compliance with formalities, to cases where consent was never truly given. Some marriages are void from inception, others voidable and only recognized until the court pronounces otherwise. Welcome to Tonik Law Partners, where we simplify complex legal issues into practical knowledge. Today, we're breaking down the exact process for annulment, how it differs from divorce, what the law says under the Marriage Act and Matrimonial Causes Act, and what it means for your rights, property, and most importantly, your children. Stay tuned, because understanding this may be the difference between freedom and years of legal entanglement, and it may just safeguard your future. If you're loving this already, go ahead, like the video, hit that subscribe button, share with someone who needs this, and tap the notification bell. Drop your comments on what topic you'd love to see next. Your suggestion could be our next video. Marriage is meant to be a lifelong union, but not all marriages are valid from the start. Some marriages may be defective either because they did not comply with legal requirements or because hidden circumstances existed that made the union invalid. In such situations, the law provides for annulment of marriage. In Nigeria, annulment is different from divorce. While divorce dissolves a valid marriage that has broken down irretrievably, annulment declares that the marriage was never valid in the first place. This video explains the grounds for annulment under Nigerian law, the procedures to follow, the difference between void and voidable marriages, and the implications for spouses and children. What are the legal bases for annulment? The annulment of marriages in Nigeria is regulated mainly by 1. Marriage Act, Cap M6, LFN 2004, which lays down conditions for a valid statutory marriage. 2. Matrimonial Causes Act, Cap M7, LFN 2004, which provides the legal grounds and procedures for annulment of marriages. 3. Case law. This is the judicial interpretations that clarify the meaning of void and voidable marriages. So, what's the difference between divorce and annulment? It is important to distinguish between the two. Divorce ends a valid marriage that has broken down irretrievably. Grounds include adultery, cruelty, desertion, etc. While annulment declares that the marriage was never valid, void ab initio, or that it was valid but defective and may be set aside, voidable. This means that after annulment, the marriage is treated as though it never existed. Let's look at the grounds for annulment. The Matrimonial Causes Act divides marriages into two categories for annulment purposes: void marriages and voidable marriages. A. Void marriages. A void marriage is one that is invalid from the beginning. It is treated as though it never took place. Grounds include 1. Existing marriage. Bigamy. If one party was already married under the Act to another person, the second marriage is void and backed by Section 33(1), Marriage Act and Section 3(1) MCA. 2. Prohibited degrees of relationship. Marriages between close relatives, that is, siblings, parent-child, uncle-niece, are void. The list is provided under the first schedule of the MCA. 3. Non-compliance with formalities. Marriage not conducted before a licensed registrar or minister. Lack of notice or publication of bans. Marriage conducted without a marriage certificate. 4. Lack of consent, where one party did not give free consent due to duress, fraud, mistaken identity, or mental incapacity. Case: Hyde versus Hyde, 1866, defined marriage as a voluntary union for life of one man and one woman, implying consent is key. 5. Age of marriage. A party under 21 without parental consent where required makes the marriage voidable and in some interpretations void. As for B. Voidable marriages. A voidable marriage is valid until a court declares it null and void. Grounds include 1. Incapacity to consummate. If one spouse is physically incapable of sexual intercourse, the marriage may be annulled. This does not include refusal, only incapacity. 2. Mental disorder. If at the time of marriage, one party suffered from a mental illness that made them unfit for marriage. 3. Venereal disease. If one party had a venereal disease at the time of marriage and failed to disclose it. 4. Pregnancy by another man. If at the time of marriage, the wife was pregnant for another man without the husband's knowledge. Unlike void marriages, voidable marriages are treated as valid until annulled by court decree. After going through the grounds of annulment, we can now consider the legal effects. 1. Void marriage. It is treated as if it never existed. Neither party has spousal rights. However, children of the marriage are considered legitimate under Section 69 MCA. 2. Voidable marriage. The marriage is valid until annulled. Rights and obligations accrue until annulment is granted. 3. Property and inheritance. Spouses lose marital rights to property or inheritance once the marriage is annulled. 4. Custody and maintenance. The court may make orders for custody, child maintenance, and property settlement to protect children and dependents. How do one proceed for annulment? The annulment process follows the same general pattern as divorce under the Matrimonial Causes Act. 1. Filing a petition. The petitioner, husband or wife, files a petition before the High Court of Estate or FCT. The petition must state the grounds relied upon, e.g., incapacity, lack of consent. 2. Service of petition. The petition is served on the respondent, the other spouse. 3. Respondent's answer. The respondent may contest or admit the petition. 4. Hearing. The court hears evidence from both sides, including witnesses and documentary proof. 5. Decree nisi. If the court is satisfied, it issues a decree nisi, temporary annulment order. This lasts for 3 months, during which objections may be raised. Examples such as appeal, fraud in obtaining the decree. 6. Decree absolute. After 3 months, if no objections are raised, the decree becomes absolute, and the marriage is officially annulled. Case law on annulments are as follows. Akinbua versus Akinbua, 1998, 7 NWLR, Part 559, 661. Court clarified that incapacity to consummate refers to physical inability, not refusal. Anyanwu versus Anyanwu, 1979, 5 SC7. Marriage annulled for lack of free consent due to duress. Brown versus Brown, 1952, WN 344. Concealment of venereal disease as a ground for annulment. Time limitations to annulment. A petition for annulment must be brought within 1 year of discovering the defect, especially for voidable marriages. Delay may lead to dismissal of the petition if the petitioner is deemed to have accepted the defect. The annulment under customary and Islamic law differs such that, for customary marriage, annulment may occur if marriage rights were incomplete, consent was lacking, or there was an incestuous union, while for Islamic marriage, a marriage may be annulled, fasq, for reasons like fraud, impotence, or failure to provide maintenance. The lessons for couples before engaging or commencing the annulment process is as follows. 1. Due diligence. Ensure all legal requirements are followed before marriage, that is, notice, registrar, consent, etc. 2. Medical transparency. Full disclosure of health conditions before marriage prevents disputes. 3. Legal advice. Consult a lawyer before contracting a statutory marriage to avoid defects. Annulment plays a crucial role in Nigerian family law. While divorce ends a valid marriage, annulment erases a marriage that should not have existed in the first place. The law distinguishes between void and voidable marriages, each with its consequences. For couples, the key lesson is that compliance with legal requirements and honesty before marriage prevents painful annulments later. If you suspect that your marriage may be defective, seeking early legal advice is essential to know whether annulment is possible and how to protect your rights and children's welfare. Annulment is more than a legal remedy. It's a declaration by the law that the marriage never legally existed. While divorce acknowledges that a valid union has broken down, annulment corrects a union that was invalid from the start. Whether due to existing marriage, fraud, duress, incapacity, or failure to meet statutory requirements, the consequences are profound. For void marriages, the law treats them as non-existent, but children remain protected and legitimate under Section 69 of the Matrimonial Causes Act. For voidable marriages, rights exist until annulment is granted, which is why timing is crucial, as petitions must often be filed within 1 year of discovering the defect. If you have reason to believe your marriage may be defective, whether based on consent issues, undisclosed medical conditions, non-compliance with legal procedures, or lack of capacity, it is essential to seek legal advice early. At Tonik Law Partners, we're committed to helping you understand your legal rights, navigate complex family law procedures, and protect your interests and those of your children. Marriage should be built on truth, consent, and compliance with the law. When these are absent, annulment may be the lawful solution. If this resonates with your situation or someone you know, do not wait. Book a consultation with us today. Thank you for watching. Don't forget to like, share, subscribe, and turn on notifications for more legally empowering content. This is Tonik Law Partners, redefining clarity in law, one case at a time.